cases were filed. And we did represent them. We were a passionate team of lawyers in Accra who handled this matter from 1986 when it was first filed. And unfortunately, I left before it was resolved. I think it was resolved, I was already at SEC, and it's now the subject of a pending motion for reconsideration.
Yeah. But you did not represent the shares of Mr. Cojuangco?
No, Your Honor.
In fact, you were on the other side.
I was for the coconut farmers who were the beneficiaries of the investments made out of the Coco Levy funds.
Okay. Now, my next question is follow-up questions on disbarment. No? Because you were an investigating commissioner.
I was also a commissioner.
Probably during the time of Attorney Binduan, no?
No, it was during the time of former Solicitor General Cadiz. He was the one who invited me to be a commissioner.
So you are familiar with our resolutions?
Yes.
I refer to the resolutions of the court.
Yes.
If the resolution of the court is for IRR, it's investigation, report, and recommendation, there is a period within which the IBP should terminate. It is usually 90 days. Okay. Once you receive the resolution of the court, the case goes to an investigating commissioner. Okay. But of course, before you start the investigation, all the pleadings are already completed because we find prima facie evidence. But after the filing of the comments, that's the time that we refer to the IBP. Okay. Then the investigating commissioner will conduct an investigation. Yeah. Thereafter, the resolution or the findings of the investigating commissioner will go to the Board of Governors because his findings is only recommendatory. Okay? I'm still precise, Attorney Herbosa? Okay.
If I remember, it was quite some time ago. Yes.
Yeah, yeah. And then the Board of Governors will meet and deliberate on the recommendation of the investigating commissioner. Okay. Whatever is the recommendation or whatever the findings of the Board of Governors, whether admonition, warning, dismissal, or recommendation for the imposition of a disciplinary action, the Board of Governors will prepare its report, attach the findings of the investigator, and refer to the court, I mean to the Supreme Court.
Yes.
Then the Supreme Court, in en banc session, will tackle that recommendation.
Yes.
Yeah. Is that correct?
Yes, I know that, Your Honor.
You know, the problem is that some say that when we refer to the IBP, there is no yet administrative case to speak of. But do you recall that when a case is referred to the IBP, that case is already docketed with an administrative case number by the Supreme Court? You remember that?
Yes, yes.
Yeah. So that's also correct?
Yes.
Okay. So now go to the other point, another point. Now you are involved in family courts.
Yes.
I think you mentioned Tornel Garda. You were a part probably of those who came out with the IRR of several. Were you a part of the...
no more.
No, okay.
No, I wasn't a part of that anymore.
Are you familiar with the dockets of family courts?
With the dockets, no, Your Honor. Maybe just informally.
Yeah, informally, but you know that there are many cases in the family courts.
Yes, Your Honor.
And the reason probably is the jurisdiction of family courts is broad and wide.
Yes.
Yeah. I give you an example. If a victim is a minor, if the victim is minor, and even if the case is only slight physical injuries, instead of that case going to the MTC on a rule and summary procedure, that case goes to the RTC and follow the regular procedure. Do you agree on that?
Yes, because the family court judges are specially trained to handle those
That's correct.
cases.
What I'm saying is that that's one of the causes of delay.
Yes.
Yeah,
As I said,
because if it is a slight physical injury, why refer to the RTC? Because the jurisdiction of the RTC in criminal cases is at least 6 years.
Yes.
But here, a slight physical injury, where the penalty merely is 1 month, should have been with the MTC on a rule and summary procedure, is it not? Yeah. So there's a problem on that. If you become a Chief Justice, what would you do with that problem? Because I think that jurisdiction, the court cannot change the jurisdiction of court. It is provided for by law.
Yes.
Is it not? Do you agree with me, Attorney Tess?
Yes. I feel that the legislation regarding family courts, the creation of special courts to deal with cases of children and women, have had the advantage of being studied and perhaps supported by data on how really cases involving children should be handled. And I think I would rely on the wisdom of the legislature in setting those parameters for
that's the good side of it. But I was just talking one of the reasons why there is a high number of cases now pending before the family courts. The other problem is that there are too many cases that are now filed before the court petition for annulment. Do you agree with me? Left and right, there are many annulment cases before the court.
Yes, Your Honor.
And probably the reason is that there is no way to separate the husband from the wife except through annulment. Is it not? Of course, you will not have that problem.
No, Your Honor. But I've talked to a lot of lawyers who handle annulment cases, and they do realize their duty to not readily advise or tell them to go for annulment, but really give the whoever is the prospective client to perhaps analyze or evaluate the problem first, see if it could be resolved, not through annulment, but through other means.
I agree with you. No? Then my point is this. No? Despite the fact that it's very hard to get an annulment of case, because it's only under one ground, the psychological incapacity.
Yes.
Although the court has been not actually lenient, but in some cases, in the case of Molina, medyo naging lenient ng konti eh. But if you look at the grounds for ground of annulment, it's very hard to prove psychological incapacity.
Yes.
If you strict about it, is it not? Because you need the totality of the evidence. Eh? Okay. But you are a Catholic, you look at the grounds for annulment under
the church.
The church. And one of the grounds is the failure of the any of the contracting parties in performing the duties.
Yes.
Of a husband, and a father, or a wife, and the mother. Is it not?
Yes.
You do not find that. You do not find that in our civil code. Do you agree with me? Is there such thing as if the husband does not give support to the wife or the children,
well, it could be taken in the general concept of psychological incapacity, that he was not prepared to fulfill the duties of marriage.
Yeah, but that's only
that had to be traced
that's
to
only
some,
one. That's only one part of
Yes.
psychological incapacity, because you have to
Yes.
take into consideration the totality
historical
of the
part
evidence.
it. Yes. So it's
Now,
easier to get a church.
No, my question is this now. Do you think that it would be better to include that ground in the church, in the civil code, so that it will be assured to annul these marriages anyway? The husband and wife do not like anymore to live as husband and wife. In fact, some of them are actually separated. They do not live together anymore. Eh?
Yes. Yes, the law should really be applicable to the general population. It did not have to just probably cater to one group. And I am in favor of, if the final question is if I'm in favor of divorce, yes.
Oh, did you read my mind? That was my next question.
Yes.
So that will lead me to the question that do you think that it would be better that we allow divorce?
Yes.
Okay. Now, I know you are familiar with the rules. In fact, you talk about modes of discovery. That's one of the modes of expediting cases, no, termination of cases. But the problem is, the court cannot tell the lawyer to avail of mode of discovery, because if you want to avail of mode of discovery, there are two ways. Before the pre-trial, you do not even need to have a leave of court, is it not?
Yes.
So at that it should be at the instance of the counsel.
Yes.
So it's not the fault of the judge. It should be, the lawyers should be taught
Yes.
that modes of discovery should be availed of. Is it not? Do
In
you-
fact,
do you
the
agree?
Supreme Court has noted in a lot of decisions the hesitation of lawyers to avail of the modes of discovery, primarily because only of the lack of awareness of probably how to do it.
That's what I'm saying.
Yes.
That's what I'm saying. I think it should be taught in the law schools.
Yes.
They do
Very
not-
much so, Your Honor,
Yeah.
because in the United States, I think the reason why they could really set a specific time within which the case should be finished, at least the trial, is because they've already gotten all the evidence through modes of discovery, and they only really present the vital witnesses.
That's correct. The other problem in modes of discovery, like in oral deposition in criminal cases, no? Usually, can the prosecution file a motion to take the oral deposition of its witness?
If I'm not mistaken, Your Honor, I think in the criminal procedure, rules on criminal procedure, there are two provisions there that somehow are modes of discovery specifically applicable to criminal cases, and I think the
Yeah, that's correct.
prosecution
That's
can.
correct.
Yes.
But the problem is this. I do not know if you read the case of Hubert Webb. Okay.
Yes.
The problem in criminal cases is that if you file a motion for oral deposition and the deponent testimony will be taken, even if the accused is entitled to cross-examination, the accused can invoke his right to confront the witness. Unlike in civil cases, because there is no right on the defendant, on the part of the adverse party to be present. But in the case of a deponent in oral deposition in a criminal case, on the part of the prosecution, the accused will always raise the objection.
Which to me is
And that is a constitutional right
yes,
to be
so
present.
it's primordial to
That's the
rules
problem.
of procedure. Yes, Your Honor.
Yeah, so we have to restudy also the rules on modes of discovery, both in civil and criminal cases.
Yes.
There is no problem if the accused is the one that will ask for the deposition of
Yes.
his witness. Because the,
That's why the two provisions,
because the
one for
complainant
the
is not entitled to be present in all proceedings in order to confront the witnesses. Do you agree with me, Attorney?
Yes.
Yeah.
In fact, that's the reason why I cited the case of People versus Hernandez, because the effect there was that pretrial rules for civil and criminal cases, they were trying to harmonize. And it did
Yeah.
result in the court recognizing stipulation facts even in
Yeah.
criminal cases.
Now, I'll go to another. I hope that if you join us as our Chief Justice, let us try to restudy the provisions on
Thank
modes
you,
of
Your Honor.
discovery. The other one is pre-trial, both in civil and criminal
Yes.
cases. Do you think that this is a tool to expedite?
Very much so. In fact, I did notice a change in the conduct of pretrial because before, and because I've been in practice for so long, the pretrial was just the judge saying, "Oh, do you are you willing to compromise or not? Not okay. We set it for trial." But nowadays, because of those rules that we have, you really have to present a pretrial brief. There should be a pretrial order, and the parties are warned that if you present more witnesses that you've indicated before, it should be for really, really valid grounds.
Not only that,
So it
if you-
does contribute to.
Not only that, in the rule for procedure in our environmental law,
Added.
we now require the lawyer to take their oath before the pre-trial, including the counsel. I mean, counsel and the party.
Yes, there are special rules for special types of cases which could probably be adopted for all, like in intracorporate disputes. In order to expedite proceedings, the parties are allowed to submit draft decisions, and the judge would just have to choose which one, or maybe adopt one entirely or in parts, which to me could also be adopted in some cases in general
or just
jurisdiction.
disregard. Or just disregard.
Or disregard too.
the
Yes, it's
draft.
like also the use of commissioners, where the judge would feel that he's not competent.
But
to
what's
go
the
for the
problem
facts.
on pre-trial? Have you encountered some problems with the rules on pre-trial in your practice? The new rules on pre-trial?
Well, that's probably one of the things that should also be emphasized in law school. Not only the trial proper, everyone is so concerned about direct examination, cross-examination. I think that should also be taught as a major part of the course on how to conduct or how to make the pretrial worthwhile part of the process.
No. Also, you talk about the rule on succession, no? Yeah. I had an experience about the intestate proceedings. I think I was not yet with the government service when that case was filed before my court. It was terminated when I was to leave my court as an RTC judge, I was able to
Effect a compromise.
Yes, effect a compromise because some of the compulsory heirs died already. It's in the records. The publisher of Iskra. I think you know the publisher of Iskra.
Yes.
But the problem in succession really is sometimes it's the rules. Is it not? It's the rules. Why? Because we allow multiple appeals.
Yes, in special proceedings, multiple appeals are allowed, as well as in
sometimes
expropriation. Yes.
Sometimes the main case is pending before the court, and the party raises an issue as to whether or not that is a compulsory heir. You go to the Court of Appeals, you cannot move, you cannot distribute because you will have to determine if it's a compulsory heir or not, or illegitimate or not, or he's an heir, or so what?
Yes. Testate cases
then
do
you have
take
to
very
wait.
long. Yes.
So what should be done? If you come here, what should be done with those rules?
Well, I'd like to tell you my favorite Supreme Court case. It was the case was already in the Supreme Court, and the question was the delay in the filing of the petition for review. And it was revealed to the Supreme Court that the reason why there was a delay in the filing of that pleading, which caused the dismissal of the case, was because the wife of the lawyer had passed away. And that Supreme Court case is kind of relatively old. The Supreme Court devoted, I think, about 10 or 20 pages talking about how it is to lose a loved one, and what tragedy it was that probably was really a good reason for the lawyer to have missed filing the pleading on time. But then in the end, the court said the case is dismissed.
Yeah.
To me, it's a good way of showing how justice should be done, how the rule should be applied. You can't really be solving all these problems about delay and congestion if you do not apply fairly standard or uniform rule that if appeal is not right, that if you miss filing the pleading within the prescribed time, then there's no choice but to dismiss it. The problem sometimes is petitions are evaluated differently by judges, from one judge to another, from one division of the Supreme Court to another, so that the result is not uniform all the time. So sometimes there were times that it was very strict and would dismiss all petitions which do not even file legibly clear copies of the attachments. Then there was a time when anybody who there was even a time that certifications or verifications signed by lawyers were rejected and caused the dismissal of petitions. Those are really good rules because they would decongest the docket of the court, especially the Supreme Court. But I suppose that in the implementation, it should not vary from division to division or justice to justice, judge to judge. It should really be equally applied. And even if it's harsh, as in the case of the lawyer whose wife died and was not able to file the pleading on time, I think whatever is provided for should be applied.
Yeah. Whatever it is, or test, of course, you're qualified to be the Chief Justice. Whatever it is,
Thank you.
I will request Attorney Rolly Bindowan to recommend you to become a member of the Mother Committee.
Yes, for the revision of the rules. Yes,
yeah.
I think you it's already on special proceedings because that's I think
so. Now my last question, you may or you may not answer my last question. Is there an advantage of an unmarried woman Chief Justice over that of a married woman Chief Justice?
No, Your Honor. I think it's the same as what we follow in ACTA. You just have to be prepared for your cases. In your case, if you're the judge, then you have to read all the documents and go through all the evidence presented.
But you will have more time.
Yes, I believe so, Your Honor.
On that note, thank you. Thank you,
Thank you.
Chairperson Herbosa. Thank you very much
Thank
for
you.
coming.
At dyan po natatapos ang interview ng ating unang kandidato para sa umagang ito, si Chairperson
ng Securities and Exchange Commission, Teresita Herbosa. Tumagal nga ito ng 2 oras.
2 oras, Robert, no?
At kasama natin ngayon si Attorney Trixie.
Ang IBP spokesperson. Ma'am Trixie, sinabi ni Chairperson Herbosa na she acknowledges daw that it is a leap of faith kung siya raw ay i-appoint ng appointing power. Sa palagay ninyo, bakit ito ang sinabi ni Chairperson Herbosa?
Well, in the first place, she's not mentioned as any of the persons na posibleng ma-appoint. So, kumbaga, very, very dark horse siya. So, considering na hindi gano'n at least hindi na-establish na may close na ties siya dun sa appointing authority, in this case, yung presidente, hindi naman siya media figure, hindi naman siya controversial, hindi naman siya babad sa limelight, then it would be, in fact, a leap of faith. Pero ang tingin ko, yung credentials naman ni Chairperson speak for themselves.
Yes.
Solid ang litigation background niya. Meron siyang family law experience. Magaling siya sa securities and financial and banking transactions. So, medyo well-rounded ang itong kandidatong to.
Napagit yung pagiging well-rounded niya. No? Napansin din natin na may mga kandidato, lalo na yung kahapon, na expert naman sa commercial law, expert naman yung iba sa economic law, ganyan. Sa palagay po ba ninyo, itong mga taong ito na may expertise sa particular field of law, ay may chance na o may magiging isang mahusay na Chief Justice?
Malalaman natin yan kapag in-examine natin kung ano yung makeup ng current na Korte Suprema. Kung makikita natin yung mga existing expertise. So for instance, si Associate Justice Sereno, alam natin international economic law ang kanyang expertise. So meron tayong doon sa larangan na yon. Meron tayong ibang mga for instance si Justice Carpio na nanggaling sa isang prestigious na law firm at hasang-hasa sa litigation practice. So kailangan ang papasok na bagong punong mahistrado ay makakabalanse, makakadagdag dun sa expertise na ngayong existent dun sa Korte. So, hindi natin masasabi kung makakabawas, makakadagdag, depende dun sa individual. Ang gagawin natin basehan yung background ng mga Associate Justice.
Attorney Trixie, Attorney JJ, balik muna tayo sa Supreme Court at ito yung interview na nga si former Executive Secretary Ronaldo Zamora. Panoorin natin to.
Sabi ng research studies, pati ng ilan na ginawa